Imagine a world where the line between potential life and recognized life blurs, and frozen embryos are legally seen as children. This is no longer a hypothetical scenario. It is the reality in Alabama, following a recent court ruling where embryos were called children. While the court's decision recognized embryos as children, it did not specify how existing embryos should be handled. Before this ruling, the realm of in vitro fertilization, or IVF, was largely unregulated. Frozen embryos, a vital part of IVF treatments, were considered property rather than potential human life. This allowed for a wide range of reproductive possibilities, from donation and destruction to freezing for future use. It also offered a beacon of hope for those struggling with infertility, including members of the LGBTQ community, who often rely on IVF and other fertility treatments to grow their families. However, the landscape of reproductive rights has drastically changed in Alabama. The recent court ruling has declared that frozen embryos are indeed children under state law, a decision that has sent shockwaves through the medical community and beyond. This ruling has immediate and significant implications for both prospective parents and physicians. For LGBTQ parents, this ruling presents a potential barrier to family growth. The ability to store, donate, or destroy embryos as they see fit is an essential aspect of their reproductive freedom. This court ruling could limit those choices, adding another layer of difficulty to the already complex process of family planning for the LGBTQ community. In terms of the broader medical community, this ruling has caused an upheaval in the field of reproductive medicine. Some patients are relocating their embryos to other states, and some IVF providers in Alabama have temporarily halted treatments due to the potential legal risks. The ruling raises troubling legal questions about the disposal or implantation of unused embryos and places an unprecedented burden on physicians to navigate these murky waters. But the implications of this ruling extend beyond Alabama's borders. It sets a precedent that could influence future rulings on abortion rights in other U.S. states. Alabama already has a total ban on abortion at all stages of pregnancy. Given the deeply ingrained political and societal divides over reproductive rights, this ruling could potentially fan the flames of an already heated debate. The situation underscores the importance of staying informed and involved in the conversation about reproductive rights. It is vital that we all understand the potential implications of such rulings, not only for the medical community, but also for individuals and families across the nation and the world. This is not just a matter of legalities and medical procedures. It's about human rights, choices, and the very essence of family. In 2021, the U.S. Supreme Court decided to overturn Roe v. Wade, which took away the right to abortion in the USA. This decision completely shifted how reproductive rights are viewed not just in America, but globally too. A lot of folks consider Alabama's ruling as just adding to the idea of attacking reproductive freedom. Alabama's court ruling could have significant implications for the pro-choice movement and abortion rights for women. By extending the legal concept of personhood to the moment of fertilization, effectively restricts women's access to abortion even further. This restriction could embolden anti-abortion efforts in other states and potentially lead to more challenges against existing abortion rights laws nationwide. Additionally, it may exacerbate existing disparities in access to reproductive health care, particularly for marginalized communities who already face barriers to obtaining abortions. What's next? Ban on regular contraception and emergency contraceptive care?